All right, class, settle down, please. Open your notebooks and let's get started. Today, we are dissecting a genuinely critical topic for your upcoming examinations, so I need your absolute focus. This explainer is going to cover Question 30, the Speaker's powers in anti-defection and the procedure for money bills versus ordinary bills. We are essentially constructing a model 16-mark answer right here, right now. And mark my words, if you follow my instructions, use this exact structure, and cite these specific cases, you're going to secure maximum marks from the KSLU evaluator. Let's begin. Here is your examiner's blueprint. 1. Constitutional rule of the Speaker. 2. 10th Schedule disqualification powers. 3. Landmark Supreme Court rulings. 4. Money bill legislative procedure. 5. Ordinary bills and joint sittings. And 6. Key differences and conclusion. Listen, structuring your answer script with these 6 exact headings signals to the evaluator that your answer is logically organized and legally sound, so do not deviate from this outline. Okay, starting with Part 1, the constitutional role of the Speaker. Now, this heading will serve as the introductory paragraph for your exam script. Under the Constitution of India, the Speaker of the Lok Sabha plays a crucial role in 2 main areas. First, deciding defection cases under the 10th Schedule, and second, determining money bills and overseeing legislative procedure. You see, the Constitution assigns these 2 distinct yet highly critical roles to the Speaker. One deals strictly with the political discipline of the House, while the other manages the financial mechanics of the state. This dual capacity is the absolute foundation of Question 30, so make sure you establish this clearly right at the start. Moving straight into our second heading, 10th Schedule disqualification powers. We are now shifting to Part 1 of your answer script, focusing purely on anti-defection. The constitutional basis here is the 10th Schedule, brought in by the 52nd Amendment in 1985. Note this down immediately. Whenever you begin discussing anti-defection, your very first sentence absolutely must cite the 52nd Amendment Act of 1985. The Speaker acts as the deciding authority in disqualification matters under this schedule, and demonstrating this kind of historical and constitutional precision right away proves your legal competence to the evaluator. Let's examine the Speaker's specific powers here. Write these down exactly as I say them. First, the decision on disqualification. The Speaker decides whether a member is disqualified for defection or for violating a party whip. Second, their quasi-judicial role. They act like a tribunal and therefore must follow the principles of natural justice. Third, they are the final authority, though this is subject to judicial review. And fourth, the power to interpret. The Speaker determines the legal meaning of phrases like voluntarily giving up membership. Now, listen to me carefully. On your answer sheets, take your pen right now and double underline the terms quasi-judicial role and principles of natural justice. Why? Because the Speaker isn't just acting as a presiding officer here. They are acting as an adjudicator. Those are exactly the high-scoring keywords your evaluators are hunting for. However, as we know, the law is never without its flaws. The primary criticisms here are allegations of bias and delay, alongside a severe lack of independence due to political influence. A high-scoring KSLU answer must always show a critical analysis of the law. You must briefly note that because the Speaker inherently belongs to the ruling majority party, there's this persistent, ongoing legal debate regarding their political independence when adjudicating these highly sensitive disqualification petitions. Right, let's move to Section 3, Landmark Supreme Court rulings. I need absolute pin-drop silence for this one. In constitutional law, citing specific cases correctly is quite literally the difference between a mere pass and a distinction. Quijoto Halohan v. Zakilhu. In your exam script, draw a bold black box around this case name. It is paramount. Let me give you the background. When the 10th Schedule was first introduced, Paragraph 7 initially barred the jurisdiction of all courts, meaning the Speaker's decision was completely immune to judicial review. Naturally, this led to massive constitutional challenges regarding the separation of powers. The ratio decidendi, the final verdict of the Supreme Court here, was brilliant. The court upheld the constitutional validity of the Speaker's power to decide defection, but crucially they struck down Paragraph 7. Why? The absolute relevance of this case is that the court declared the Speaker acts as a statutory tribunal when deciding these matters. Therefore, their decisions are absolutely subject to the judicial review of the High Courts and the Supreme Court under Articles 226 and 136. But, and this is a big but, only after a final decision is made by the Speaker. Write this detailed ratio exactly as I've explained it. Next up, Mohammed Saeed Siddiqui versus State of Uttar Pradesh. Underline this case name prominently. Let's break it down. The background facts involved a legal challenge against the Uttar Pradesh state legislature, where a particular bill was certified as a money bill by the Speaker. The opposition argued this was legally improper and just a tactic to bypass the upper house. So what was the verdict? The court strictly held that the Speaker's certification of a money bill is final under Article 110 or the corresponding state article, and that judicial interference is very, very limited. The relevance of this case is massive. It establishes the absolute procedural supremacy of the Speaker in the realm of money bills. Once a Speaker signs that certificate, the courts will generally refuse to investigate the internal proceedings of the legislature. Okay, shifting gears entirely now, Section 4, Money Bill Legislative Procedure. We are transitioning to Part 2 of the lecture, moving away from the defection paradigm and entering the strict mechanics of legislative procedure. I want you to create a fresh subheading, Money Bill, Article 110, a bill that strictly deals with taxation, borrowing, or the consolidated fund. I need you to memorize Article 110 right this second. Do not simply write financial matters on your exam. You must explicitly write these 3 specific conditions on your paper: taxation, borrowing, and the consolidated fund. This exact wording is required to demonstrate to the evaluator that you understand the strict constitutional definition. Now, note down the procedural steps carefully. Step 1. It can be introduced only in the Lok Sabha. Step 2. It requires the prior recommendation of the President. Step 3. The Speaker certifies it as a money bill, and as we discussed, this is a final decision. Step 4. It is sent to the Rajya Sabha. They can only recommend changes, and they must return it within 14 days. Step 5. The Lok Sabha may choose to accept or reject those recommendations. Step 6. It's sent for the President's assent. I want you to heavily emphasize 2 things in your notes right now: the 14-day limit for the Rajya Sabha and the Speaker's final certification power. If the Rajya Sabha just sleeps on the bill for 15 days, it's legally deemed passed. The upper house is effectively financially toothless here, and the Speaker is the ultimate gatekeeper. Next up, Section 5, Ordinary Bills and Joint Sittings. Begin a new subheading to contrast the ordinary legislative process with the strict financial procedure we just covered. The procedure for ordinary bills is as follows. Step 1, can be introduced in either house. Step 2, no prior recommendation is needed, except in a few very specific constitutional cases. Step 3, it absolutely must be passed by both houses. Step 4, in case of a disagreement, we have a joint sitting under Article 108. Step 5, sent for the President's assent. In your notes, right now, circle Article 108, joint sitting. This is the crucial procedural divergence you need to highlight. Money bills never, ever go to a joint sitting. Ordinary bills do, whenever there's a deadlock. Highlighting this shows the evaluator you understand the equal footing of the Rajya Sabha in ordinary legislation. And finally, Section 6, Key Differences and Conclusion. We are entering the final segment of our model answer. Listen to me, comparative tables are actively sought by KSLU evaluators. It shows incredible clarity of thought. Let's compare them. Basis, article. Money bill is Article 110. Ordinary bill is general provisions. Basis, introduction. Money bill is only Lok Sabha. Ordinary bill is either house. Basis, Speaker's role. Money bill, the Speaker explicitly certifies the bill. Ordinary bill, they have no such power. Basis, Rajya Sabha. Money bill, they have an advisory role only. Ordinary bill, they have equal power. Basis, time limit. Money bill is a strict 14 days. Ordinary bill has no limit. Basis, joint sitting. Money bill, not allowed. Ordinary bill, allowed. I am forcefully instructing you to draw this exact matrix on page 4 of your answer booklet. Use a ruler. Keep it extremely neat. This table alone condenses pages of complex legal theory into one highly scorable format and will practically guarantee you full marks for this section. We conclude your answer script with this text. The Speaker plays a vital role in both anti-defection and legislative procedures, ensuring discipline and efficiency, but raising concerns regarding impartiality. Write this text exactly as it is. It's the perfect concluding paragraph. It neatly balances the functional necessity of the Speaker, which is keeping the House running smoothly and preventing political horse trading, with the critical jurisprudential need for institutional safeguards against potential political bias. I will leave you with this final provocative thought. If the Speaker's powers are essential for legislative efficiency, how do we legally solve the inherent conflict of their political impartiality? This is a classic exam-style jurisprudential question. Do we adopt the British Convention, where the Speaker officially resigns from their political party upon taking the chair? Or do we create a completely independent tribunal for defection cases? Challenge yourselves to think beyond the textbook. Master the structures and case laws we cover today, and you will absolutely master constitutional law. Class dismissed. Keep studying.